Caleb Thorne was a historical land use researcher whose passion lay in the dense, forgotten archives of American settlement. His expertise was in tracing title chains not just through deeds, but through the original land patents, government grants, and water rights established before the advent of modern zoning. His life in the sprawling, exclusive community of Riverbend Heights was usually quiet, until the HOA, under the self-important guidance of President Leonard Mills, decided to flex its regulatory muscle over water. In response to a local drought advisory, the HOA passed an immediate, aggressive new rule: all non-culinary water use, including landscape irrigation, must cease or face escalating fines of $250 per day. The rule was enforced indiscriminately, targeting residents whose lush lawns and gardens relied heavily on supplemental watering. Caleb, whose meticulously maintained heritage garden was his pride, received the first fine after his irrigation system ran for exactly 22 minutes one morning. He tried to explain to the HOA management that his irrigation system drew from a private, registered well located entirely within his property boundaries, not from the community's shared municipal supply. Leonard Mills rejected the argument with dismissive arrogance, stating in a community-wide email that all water, from the roof to the tap, is subject to HOA jurisdiction for the greater good of the community. The $250 fine was swiftly levied. Mills had assumed that private covenants, especially those concerning the public good of water conservation, superseded a mere private hole in the ground. He had just made the mistake of challenging a man who spoke the language of the 19th century General Land Office. Caleb did not pay the fine. He did not argue with the management company. He launched a deep dive into the property's origin. He knew that water rights, especially in older Western states governed by the doctrine of prior appropriation, first in time, first in right, could have seniority far superior to any modern residential covenant. His home stood on land that was originally a sliver of a vast 19th century agricultural claim. He began his research in the county assessor's office, but quickly moved to the state archives, tracing the patent chain back to the 1880s, when the land was first homesteaded. His breakthrough came in the form of a faded, handwritten record, an original notice of intent to divert filed in 1891 by the original homesteader, one Elijah Kincaid. This filing, a legal prerequisite under the then new state water code, claimed the right to divert a specific volume of groundwater from the Kincaid property for agricultural and stock watering use. This filing was subsequently acknowledged and ratified by the State Water Commission in 1905, establishing what is known as a senior water right, a right that predated the existence of the city, the county's modern zoning ordinances, and critically, the establishment of the Riverbend Heights HOA by nearly a century. The original patent was explicit: the land was conveyed with the water right attached, making that right an inseparable, protected asset of the property. The private well Caleb used was the direct lineal descendant of Elijah Kincaid's original 1891 appropriation. The implications were absolute and stunning. The HOA's entire legal authority stemmed from the community's 1998 Declaration of Covenants, Conditions, and Restrictions (CC&Rs), a document subordinate to the state's fundamental water law. An 1891 senior water right was essentially a permanent, state-protected property right. The HOA could regulate the color of a mailbox, the height of a fence, or the type of shrubbery, but it had zero authority to restrict a water right granted by the sovereign state over a century before the CC&Rs were written. The HOA's new water rule was not just wrong, it was ultra-vires beyond the scope of their legal power. Caleb compiled his evidence: the 1891 Notice of Intent, the 1905 state ratification, the chain of title proving the right ran with the land, and his own surveyor's report verifying the well's connection to the appropriated groundwater source. He bypassed the HOA's internal appeal process entirely, viewing it as a bureaucratic sham. Instead, he filed a petition for declaration of vested water right exemption directly with the State Water Board. He was not asking for permission. He was asking the state's highest water authority to formally recognize and reaffirm an existing superior property right. The State Water Board is a body that deals with large-scale municipal, agricultural, and industrial water issues, not petty HOA disputes. However, the rigor and historical depth of Caleb's submission caught their immediate professional attention. The board's chief counsel, recognizing the potential precedent, issued a formal legal inquiry to the Riverbend Heights HOA, demanding they justify their attempts to restrict a documented 1891 senior right. Leonard Mills and the HOA council were blindsided. They had prepared for a local civil fight over bylaw interpretation. They were now facing the full legal and historical weight of the state's paramount water authority. The HOA's attorney tried to argue that the CC&Rs constituted a voluntary agreement by the homeowner to abide by all rules, but the State Water Board's counsel quickly rejected this claim. They clarified that a private covenant cannot supersede a pre-existing state-vested property right, particularly one involving essential resources like water, unless the right was formally relinquished, which Caleb's right had never been. The HOA's water use rule was therefore unenforceable against Caleb's parcel. The final ruling from the State Water Board was a masterpiece of legal clarity and a complete demolition of the HOA's authority. The board issued an official administrative order upholding Caleb's claim. The order declared that the water right attached to Caleb's property, derived from the 1891 appropriation, was senior and superior to the Riverbend Heights Declaration of Covenants. The order explicitly stated that the property at 412 Whispering Creek Lane was permanently exempt from any HOA rules or assessments related to the use of groundwater drawn from its private well. This was more than an exemption. It was a permanent, state-protected shield against any future HOA attempts to control the property's water use. The financial and political fallout for the HOA was severe. They lost all authority over a vital natural resource, permanently diminishing the perceived power of the board. The court ordered the HOA to immediately refund all fines levied against Caleb, totaling $750, and more painfully, cover all of Caleb's extensive legal and filing fees incurred during the State Water Board proceedings, which totaled over $15,000. Furthermore, the public nature of the State Water Board ruling made the entire fiasco highly visible. Leonard Mills, who had based his presidency on his strict enforcement of community rules, was publicly humiliated by the revelation that his central water policy was illegal. Facing a furious community that realized their dues were paying for the defense of an indefensible violation of a 130-year-old law, Mills resigned immediately. Caleb Thorne, the meticulous researcher, continued to cultivate his heritage garden with water from his protected senior well, his lush lawn a perpetual legal testament to the unassailable power of history and the law of prior appropriation.